Our next case is State for Restivo et.No. for City of Avon. Have all our counsel ready? We're a little early. Is anyone, are you expecting any of the parties to be here? Any need to wait for anything?
No, Your Honor.
No, Your
My
Honor.
client's
Good. Very good. Thank you all. Each party will have 15 minutes for their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve for rebuttal?
Yes, Your Honor, 5 minutes.
I will make note of that. Because I'm keeping time up here, I will attempt to let you know when you're about a minute left in your initial time. I won't make any comment about rebuttal time, so you know if that initial argument, I'll let you know about a minute left. And then I understand there's, you two folks here today understand you need to divide your total 15 minutes up in some capacity.
Yes, Your Honor.
Just, how are you, do you know how you're doing that?
The plan is, and I'm counsel for Carnegie Residential Development, I'm going to go first. I'll have 10 minutes, and then counsel for the city will have 5.
I'll try to make that same notation for you, have a minute left. If he keeps talking, it takes your time, my apologies, you have 15 minutes.
Yeah.
And that's where we're going to be, okay?
Thank you, Your Honor.
Sure. The arguments are being recorded, so when you come up to the podium, make sure you introduce yourself, number one. Make sure you stay behind the podium, and you speak loud enough so we can hear you. Stay behind because we're video recording you, and if you move, we may lose the audio, and more, and certainly we'll lose the video at that point in time. I don't think it really is applicable to this case, but if you use it, any children, minors, or victims, use initials rather than their name, I don't think we have anything like that here for you. But with that, we're ready to proceed whenever you are.
Good morning, Your Honor. My name is Gerald W. Phillips. I'm here on behalf of the appellants. This appeal really is centered on two issues and two major questions. It deals with the exhaustion of administrative remedies, which is an affirmative defense pursuant to the rules you would plead it under, in your answer as an affirmative defense. The Supreme Court, in the case of Jones, indicated that it is an affirmative defense. So it also focuses on Civil Rule 57, which is the declaratory judgment. A lot of people just call it a DJ action. Rule 57 indicates in the language that it is an alternative remedy. And it also states when it's appropriate, and that's the wording in the civil rule. So case law has come up with, exceptions. So you don't have to exhaust administrative remedies. You don't have to do that if you fall in one of the exceptions. And case law has come up with a number of exceptions. The Schaefer case talks about when the declaratory judgment will give you a speedy relief when you need one, or you need one to prevent lost rights, which tends to center on like injunctive relief, either preventative or mandatory injunction. The other one is a concept of what they call equal servable. Okay, if the administrative remedy, which is in this case 2506, is the administrative remedy, if that remedy is equal serviceable, then you have to pursue that. And the courts have defined that in the sense that, the same relief that you would get in a declaratory judgment, if you can get it in the administrative appeal, then it's equal serviceable and you can't do the declaratory judgment. Also, an exception is when the administrative remedy would be undue burdensome, and that's the Burt Realty case. And then also another exception has to do with the fact of a vain act. And the courts have defined a vain act is in a situation where the administrative appeal will not give you the relief that you need. In this particular case, a 2506 appeal, you don't get an injunctive relief. You just get a decision whether or not the decision is affirmed or reversed. So you can't get injunctive relief. So
No, you can request a stay in an administrative appeal, which stays the action at that point in time, if the court wishes to grant it, of course.
yeah,
And that, similar to an injunction, that permits the prohibits the parties from acting further to make any improvements.
Yeah, but in that particular case, in administrative appeal, you have the same issues as far as posting bond. So yeah, you can get somewhat of a administrative relief. But in a declaratory judgment, you can't get a mandatory injunction, which is forcing somebody to compel with the law. In this particular case, there's alleged that, City of Avon, under their stormwater management, chapter 1050, they have situations where any violation of those stormwater is deemed to be a public nuisance. That's 1050.99I. So any violation of that stormwater provisions, which is the allegations in the complaint, injunctive relief, could be a remedy. In fact, that section declares any violation of that a public nuisance, which is the other area in this appeal that I believe the trial court made an error on. So the trial court.
So your view is all of those exceptions under Rule 57 apply to this case? Not that any one of them, you cited them all, so you think
Yeah,
all?
but I believe that those are factual issues, okay? And generally, affirmative defenses aren't granted on a 12b6 motion because all the allegations are accepted as true. There are some rare exceptions, like statute of limitations sometimes. You can get a 12b6. Res judicata, you can't, generally. And the case that they cite, the Rocky Fork Hunt case, if you really look at it, in that case, they actually filed an answer in that case. They did assert affirmative defense. So, also there was a summary judgment, and that was opposed. And when on appeal, they reversed the summary judgment for the plaintiff and basically granted, opposite, saying that the exhaustion of administrative remedy barred it. Now,
Also during the appeal, it seemed like, I don't know if they raised it at trial court level, but certainly during the appeal, it seemed they raised the issue that this action was moot because the construction, the plat been approved, the construction taking place, now it's moot. And there's a line of construction cases where they do seem to indicate cases are moot. Why is this action not moot?
well, we're not seeking the undoing of the construction. We're seeking enforcement of the stormwater management, which is injunctive relief. And we can get a mandatory injunction to force them to cure the nuisance if there's a public nuisance. And violate, 1050. The trial court basically said it's a private nuisance, okay?
Did you, when you responded to their motion to dismiss, did you make this argument about curing the nuisance at that point in time?
Yes. Now, a nuisance.
I'm a little confused with that because
Okay.
You also said in order to get your, one part of your injunction though, I think one of the remedies you're seeking is to overturn the village's or the city's determination or acceptance, of this plat of land and basically approving it and saying it's met all the requirements of the city.
Yeah, but under ORC 71119, in the record, prior to getting to here, we had a lot of issues about jurisdiction. In fact, the clerk directed us to brief that issue on jurisdiction, and we did. And the issue was whether or not it was a final order, or whether or not they actually did a declaratory judgment.
But what does that matter if it's moot?
If it's moot, I don't believe it's moot.
I know, but I'm just saying you're making these arguments, but in reply to Judge Stevenson's question about mootness, I'm trying to figure out why it's not moot. Because I know you weren't trying this, you said you weren't trying to stop the construction, but in essence, you were trying to stop the construction because you were trying to overturn the city's approval of the construction.
No, acceptance.
Okay, acceptance of it, all right.
Except, there's three stages. There's, they were at the stage of acceptance of the improvements. They were at that stage. And acceptance only occurs engineer comes, and I cited that in Exhibit Q, when I said that there's a third step in the process as far as administration. There's the preliminary plan, there's the final plan, and then there's acceptance of the improvements, and that's when the plat gets filed. Now,
And they've accepted the improvements.
yes, they have, subsequently to
And
the
it has
appeal.
not been stayed, and then either no stay or any action by a court telling them not to do that.
No, but that doesn't prohibit the remedy of curing the nuisances, all right? I mean, 1050,
Curing the nuisance would in some way, and you're about a minute left of your time, would in some way mean changing this system that they've already approved, would it not?
no, not necessarily. It would deal with the improvements that are not proper. I mean, a nuisance action, still would exist.
But
Whether,
I'm having a hard time because of the fact that the city already accepted it and said it does meet the requirements of the city. So you're trying to overturn a legislative or an administrative action. And I'm trying to figure out how does that relate to the nuisance or your causes of actions here?
well, the acceptance of the improvements dealt mainly with the streets and the roads and the sewers and the undergrounds, okay? That's, when you file a plat, and that, they're all on there. There's other requirements, for a subdivision that don't get recorded on the plat and aren't accepted.
And you're now into rebuttal time. You can keep going, but it's up to you. You're in rebuttal.
No, I'll stop, thank you.
Very good.
May it please the court. My name is John Slater, and I am counsel for the defendant appellee Carnegie Residential Development Corporation. I have with me in this courtroom one of the representatives, Jonathan Corey, who is part of the family that is the owner of Carnegie Residential Development Corporation. We appreciate your time and consideration of this matter. I'd like to begin with the standard of review for this 12B6 motion to dismiss, which, as brief, it is the de novo standard. And just as the experienced trial judge indicated and recognized, whether us as the defendants agree with any of the allegations and factual allegations in the complaint, it's irrelevant. We've never got to that point. We assumed that those factual allegations were true, and the trial court did the same, and that's your obligation. And as we sit here today, looking at and testing the factual allegations of the complaint is a purpose for the 12B6 motion to dismiss. And that's exactly why we filed the motion, and we believe that the court properly looked at all the issues and made a proper decision to dismiss this case for failure.
I'm sorry, go ahead.
Yes.
Go ahead.
Exhaust administrative remedies.
It seems though that the court was looking beyond the allegations in the complaint. I mean, you raised a affirmative defense, a failure to exhaust administrative remedies in your motion to dismiss, which you probably do agree, right, that it is an affirmative defense?
It is an affirmative defense,
Well, how
yes.
do you do that on a 12B6?
Because when the allegations in the complaint are accepted as true, and which we do, and the action that they're challenging based on the allegations in the complaint, which is the determination by the city engineer that this development fit under the statutory exception in the local city code. If you boil it down, that is their exact claim, that the engineer's decision that this development contained what's called, in the codes it's called SCM, Stormwater Control Measures, which is, and again, this is all from the complaint, all the improvements that they did when they built the golf course. So the engineer has the ability to do that. And so when that engineer's decision says this development is an exception under the rules because they have adequate stormwater controls, and right in their complaint, it's all set forth. And that these controls, by the way, existed since 19 98 for 27 years. So, you know, typically you would raise this if there's factual issues around based on in the complaint that whether the affirmative defense applies or not. Here it's crystal clear. First of all, what's clear, Your Honor, is the case law says, and even beyond the case law, if you look at what's being challenged, when there's an administrative decision, we know under 2506 that is the vehicle to challenge it. And you have a 30-day period to file that appeal under 2506, or 250507. There's a 30-day period, and if you don't, then you are prohibited from bringing that action or that challenge. And that's...
In the complaint, does the plaintiff allege that they never filed a 2506 appeal?
They did not, but the allegations that were there, and you can have reasonable inferences from the facts, is that there's no question they were challenging the engineer's decision, and ultimately that led to the approval of the final plat. And the case law is clear. Approval of the final plat is the administration of law, not creation of law, legislative act, and therefore subject to 2506.
I guess my concern is if we would say that a 12B6 was appropriate here, we would, by inference, basically saying that when a plaintiff files a complaint, they also have to allege enough in it to say that they complied with all the possible affirmative defenses. And I don't think that's the law, is it?
You don't have to, in the complaint, allege that, but if the complaint is factually stated on its face, identifies, and just like a statute limitations claim or otherwise, which can be applied in a 12B6 and the other defenses that come up, it determines whether you have a justiciable controversy. And there's case law that indicates that an administrative appeal is a prerequisite to any other type of challenge. I handle a lot.
I'm sorry. Any of the case law that you cite or you're aware of that dealt with exhaustion remedies and being dismissed by 12B6 rather than some other capacity?
The case law we cited talked about we did cite cases that allowed the 12B6 dismissal.
But they were converted to summary judgment.
Excuse me?
They were converted to summary judgment, though.
Yeah, those ones were converted to summary judgment, correct. And here there was no attempt to convert it to a summary judgment or otherwise. And again, if you look clearly at the facts and what had occurred and what they're challenging that adoption of the final plat, which they knew, again, back on September 22nd, or September of 2022. And so again, this case is about responsibility of all the parties. They've sued us, the developer. They have sued the city and all the council people, claiming we did not follow our duties or responsibilities. But the fact of the matter is, the litigants and the plaintiffs also had a responsibility. One, to file an administrative appeal, which they clearly had the right to do, and they never in their complaint asserted that any of these remedies or otherwise were not available, that it was too costly or otherwise. And if you just look at the face of the complaint, look at their challenge. The engineer's decision that they need an exception was improper, and therefore we needed a stormwater plan. Nowhere in the entire complaint, and they give a whole history since 1998 of red tail development, do they ever say there's been flooding from red tail. They're basically asking this court for an advisory opinion saying, well, there might be a nuisance out there. And in their complaint, they talk about this development. We're at phase 19. It's been going on since the 1990s, reviewed by engineers, and no allegation of any flooding.
Moving to the question of movement,
Yes.
we're running a little bit out of time here, I want to talk about
Correct.
that. Did either your client or the city argue movement at the trial court level?
We did not argue it at the trial court level. Well, actually, I don't believe we do. I think we brought it at the court.
As a motion to dismiss at the Court of Appeals, is what I can see from the record.
Correct, because we filed right away the motion to dismiss. It took some time for that ultimately to be decided by the court. And I think that may be the reason.
Eventually, the appellant just kind of procedurally responded to your motion to dismiss. I think you and Carnegie in particular had a response.
Correct.
Did you file a response to that? I can't see one in the file. Did you respond to their response to
Yes,
your?
I believe we did. There was one in the file.
Okay, I couldn't find one. If I'll look for that.
Yes.
What is your response to their argument they're making today about,
Sure.
they're a nuisance and you still court can look and see if there's a nuisance, as far as the movements go?
Okay, so as far as the mootness, I think the mootness is crystal clear. They claim, well, we're challenging just the acceptance of the improvements, right? That decision, but when you read their complaint, what they're actually challenging is a decision of the engineer which approved the plat. And they're saying you have to follow the stormwater rules, which are right in their complaint. The stormwater rules say you cannot do any construction activity until you get your permit or you're exempted from it after engineering review. And we did that, got approval, and what did we start doing? We spent $1 million putting in the improvement. And then they wait, they don't file a stay with the court, don't file an administrative appeal, don't file an injunction or a stay with this body, which they had a right to do, and the case law is clear, you can't sit by. They have duty and responsibility too, even if they're right. They would have had a duty and responsibility rather than my client putting in $1 million of improvements, giving them to the city, and then say, well, there might be a nuisance out there, we don't know. You know, there's-
So basically, are you saying in your argument that you are, it is moot because they cannot be overturned? That the engineer's decision cannot be overturned?
Right. The proper way to have overturned the decision of the engineer would have been to file an administrative appeal. And in fact, you would have had it done administratively, and then the next step is under 2506 to the court. And that remedy, if they were correct, the court would have said, yes, you're right, this interpretation by the engineer is wrong. And then at that point, you know, we would not have been able to move forward with our development. But instead, they sat by. They allowed us to do it. And the case law says when you start construction, they waited until construction was over. And so it's smoke and mirrors that says, well, the city's getting this dedicated plat. That's not the issue. The issue was the construction and whether that was allowed to start without a complete stormwater plan. That's their argument. And by the way, they've indicated that there's been plans in place since 1998, and they admit that the engineer for the city, who's been paid millions and millions of dollars, spent significant time reviewing this, and they were at the meetings and they objected. They just never moved forward with their legal rights and have constantly raised these issues.
Your answer took you about your 10 minutes.
Okay, then I'm going to sit down before co-counsel sheets, make sure.
May it please the court, Stephen Bozak on behalf of the city of Avon. I want to start with Judge Carter's question about the exhaustion of remedies on Rule 12b6 motion, and I want to direct the court's attention to, it's a case that we had cited in our brief, the city's brief. It's OMG MSTR LSCO LLC. It's, I believe it is 2018 Ohio 4843, and that's a case out of the 10th district that kind of took this issue head on, where it was a 12b6 motion on a declaratory judgment action, and the defense that was raised was exhaustion of remedies. And like here, the court questioned whether you could seek a defense or assert a defense of affirmative or exhaustion of remedies at a 12b6 stage. And the court said where it was clear from the face of the complaint, including all inferences and everything that's attached, that you could consider exhaustion of remedies. And I think the comment that Judge Carr brought up about, would the ruling require this court to be too broad, where to put the burden on the plaintiff that they have to affirmatively plead in response to certain affirmative defenses? I don't think it needs to be that broad, and I also think when this case presents a special circumstance because the declaratory judgment is arising from a political subdivision's decision, and if that is the case, I think, then yeah, I do think there's a burden on the plaintiff to affirmatively say, I've covered my administrative appeal, or I've done what I need to get to the declaratory judgment stage, because I think the case law from both this court and I think the Supreme Court says that if you are going to pursue a deck action to challenge an administrative decision from a political subdivision, you first have to exhaust your administrative remedies. And that is a prerequisite, I think, recognized across Ohio. And so if that's the case, and you're going to then plead a declaratory judgment action, then yes, I do think it's important that the plaintiff acknowledge in their pleadings why they had not exhausted their administrative remedies. And so I think this court should follow the 10th district in that case to say where the complaint itself shows that there was no exhaustion of administrative remedies, then yes, you can make that decision on the 12b6 standard. And I do think it's important that the argument from appellants is not that they tried to administratively appeal. The argument is that they weren't required to. So there's no dispute that there was no attempted administrative appeal here. So I do think 12b6 was a proper standard to deal with that defense. And I
Of course,
also,
since you didn't actually file an answer, how do you raise an affirmative defense without filing an answer? I mean, you could have filed one of two things could have happened, seems to me. The trial court could have converted it to summary judgment and said, this is not really a proper vehicle for a 12b6. Or you could have filed an answer and raised the affirmative defense and then asked for a judgment with pleadings. But I'm just still struggling with that. We'll read those cases. I'm just struggling with, since it was an affirmative defense, it has to be raised in an answer or a plea.
I think,
And before you answer her question, you have about a minute of time.
yeah, and so I think the 12b motion is an avenue to assert certain affirmative defenses, and I think here it would include this one. But again, I'll defer to the court to those other decisions and to look at the fact that there is no dispute that there was no administrative appeal filed here. I do want to quickly touch on the standard of review because I think there needs to be a tweak that I think I wish I would have raised in my opening brief, but I think I can do so now. Generally, a motion to dismiss is a de novo review, but when you're dealing with a declaratory judgment action, I think the Supreme Court counsels that you should apply an abuse of discretion standard to questions of justiciability. And that is the R-Not case. It's 2012 Ohio 3208. And that talks about applying abuse of discretion to
So
certain
this is
parts.
not your brief?
This is not my brief,
You
so
have to file by local rule, a motion to supplement your brief in any case law.
I understand that, and I wish I had discovered this earlier. I just want to raise it to the court's attention.
Well, that's the whole point of the local rules.
Yeah, that ties you then. And also note your overtime, if you would briefly conclude, please.
Absolutely. So I'll ask the court that they affirm the trial court's decision. Thank you.
Thank you.
To answer a couple of questions, the plaintiff doesn't have to plead and negate in their complaint that no affirmative defenses exist. In fact, if you read the rules, okay, when you file an answer and you assert your affirmative defenses, no reply is permitted unless the court orders it. So because no apply is required, it's automatically denied, okay? And therefore, any affirmative defenses would be denied. And what they're talking about is, what they want this court to say that there's no remedy if somebody puts in a development and it turns out to be a public nuisance, that the city cannot enforce the law to cure that public nuisance.
I don't think that's what they're arguing. I think they're arguing that you did have a remedy, and that was through the administrative process.
Yeah.
So there is a remedy for the public. There is a remedy for an individual property owner.
Yeah, but it's not necessarily a property owner, okay? I believe one of the other areas that the trial court erred is their determination that there was no public nuisance. 71544 is the statute that gives municipalities the ability to legislate against nuisances. And in that statute, nothing says that about public. And the Akron case, Klein case, said that you need to put public in there because a city cannot legislate against private nuisances. They can only do public nuisances. So when they enacted 1050, chapter 1050 and all those requirements, they had to be a public nuisance or they couldn't enact that section. And the court took a very narrow approach of what a public nuisance is, saying that it's gotta cover the whole city, okay? If you read the case law, a public nuisance is something that covers, more than a narrow group of people. And we have exhibits A through D dealt with 4 moratoriums. So when they say flooding wasn't an issue in Avon, that's absolutely wrong. Because in the ordinance, exhibit B, they have a map. And you can look at that map and see it covers a huge portion of the city of Avon. And the fact that they had 4 moratoriums, they stopped development in the southeast quadrant where Red Tail is, because that's the major source of the French Creek watershed. To say that flooding is hypothetical, why did the city of Avon then enact 1050 after the 2014 flood? And they've had floods subsequent. So I believe it's clearly a public nuisance. Because otherwise, why did they do the moratoriums? Why did they enact 1050 to cure the flooding problem? Because if it wasn't a public nuisance, 1050 is illegal. They can't legislate for a private nuisance. They can't legislate, for me, a private nuisance between our neighbors. It's got to be a public business. They can't do private. So I believe it was a public. And the cases they cite, there's some cases about taxpayer individual interest. You look at all those cases where they said that the taxpayer was pursuing their own interest. It dealt with unions, police, fire, Teamsters, that were doing the taxpayer action. None of them dealt with an ordinary citizen bringing action on behalf of all the residents to cure a public problem. So I believe it's a public nuisance. And therefore, if it's a public nuisance, the remedy against that is injunctive relief by their own codified ordinances. So if you can't cure a public nuisance after the fact, after the plat's approved, does that mean that you can never seek a remedy to cure a public nuisance? I don't think that's the law. That means you can never pursue a public. That means the city couldn't cure anything that they may have approved. They'd have to live with the public nuisance. So 71544 in the Akron case and the Brown-Bernard case says that you can only the city can only legislate for public nuisances, and that's what they did. So there was a public nuisance.
Mr. Philip, your time is up. You may briefly conclude.
Well, we talked about the 4 exceptions. I just want to point out.
Well, don't go to a new thing. You may make a brief conclusion. No new argument. If you have any conclusory statement you'd like to make, please do.
Yeah, well, we alleged in the complaint that there was no adequate remedy at law, which is a requirement for a declaratory judgment, also mandamus action.
All right. Thank you, Mr. Phillips. The court will take the matter under advisement, issue a decision
Thank you.
in due course. With the clerk of court will mail a copy of that decision to you upon its release, and it will also be posted on the Ohio Supreme Court website. With that, I'd like to thank all 3 of you for your presentation